All right, so we are now live. So the people are here with us. Cool, cool, cool. So first, let me see. Let me put this in so I can hear you and not get any feedback. But yeah, I definitely just want to hop into the conversation, kind of tell the people who you are. Why did we bring you to the stage? You're very well versed in this space, specifically legal and etc. So just kind of lead us off with talking about yourself.
Okay. So I'm Alexia, Lexi McWhinney. Mm, I currently serve as the COO at J. Jackson Law Office, where I oversee basically everything operations. But I am an attorney by trade. I do still practice, with my main practice areas being business law, and then probate and estate planning. So that said, I handle all kinds of business, legal, and consulting types of like matters for my clients. And I do quite a bit of work with intellectual property, certain aspects of it anyway.
Okay, good deal, good deal. So you're well versed with intellectual property, business operations, and as it relates to legal. This is very important. So I'll kind of tell the people and yourself about a dive into Black creators, what kind of inspired this event series, and then specifically protecting your IP and publishing content.
Okay.
So a dive into Black creators is just to simply shed light on Black creators, right? So the creator economy is booming. Almost every industry is reaching in for influencer marketing or some type of UGC and et cetera around the space. And so I have a few friends that are influencers and I have conversations with them and I notice the lack in their like incoming accounts. So like there are no brands that are reaching out to them. Maybe their pay is lower than some of our other counterparts. And so I was like, we have a platform. AMA has created a community of Black professionals. Some of these same professionals are in position to, help these creators, and if not, shed light in these C-suite spaces. So that is what a dive into Black creators is and about, and kind of the idea of birth in itself. But today's event, as you know, but the people do not know, today we're going to be talking about like IP. We have I put a few little questions in there, y'all, so there may be some good ones, some good information coming out. But we're definitely going to focus on like copywriting, trademarks, and the like in the space. So we kind of heard a little bit about you. We got a bit about what the idea of this event is and etc. So I kind of want to start off with talking about like the differences between a trademark, copywriting, and a patent, because I think a lot of people get confused with those.
Okay. So when we talk about copyrights, that's the thing that most people, I guess, are most laymen are familiar with. Just because you hear I'm a copyright, I got a copyright. That is protection for like a work. Like typically, that work is either written, composed, um, or created in a medium, art. So those are really where you see the application of copyright. It protects those types of works, right? A patent typically protects processes. So how you do something or the way something is made that makes it unique, the design of a particular thing, that's where we start talking about patents. The ingredients, the makeup of some kind of product. That's where we really see the application of patents. And then trademarks is the protecting of brands, basically.
Okay.
Brands in the form of words or in the form of symbols. So you have word marks, which can be individual words,
Okay.
Apple, Google, right? Or you have phrases, just do it.
Mm,
So it can be phrases that are related to brands, right? Or it can be business names that you may not have ever heard of, right? It can also be the logos. So a lot of times when we hear trademark, I'm a trademark my logo, my logo, my logo. It's really a design mark that
mhm.
somebody is trademarking. And so it's a protection of something related to the brand itself. So it's a little
Yeah.
bit less tangible.
Okay. And so I think that's the big thing when this conversation around creators comes up. It's like copyright. Do I copyright my content ideas, my the content in itself? I consider myself a brand. Do I trademark my catchphrases? So a lot of creators, including myself, get confused on that one side piece. And so, as you just explained to us, a patent is like the formula. I'm protecting ABC, which will equal up to whatever that equals in math. And then also like a copyright is like copywriting. Did you say it's like a bit more elusive? So
like
like
a work, like a work.
yeah.
Maybe it's a poem or a piece of art or a song, because that's a written work. A song is a written work. So it's more, that's what it pertains to. Copyrights are works that are things that are authored, basically,
Okay.
are copywritten.
Can you see like a creator? So let me give you a scenario and then we can kind of explore a little bit. So let's say a creator does get an LLC like for their creation. Then could they go explore like a trademark or copyright?
So I'm so glad you asked that, because I want to unpack that, because I think
Okay.
specifically since COVID, everybody and their mama been talking about LLCs. I got an LLC, I got an LLC.
Yeah. Yeah.
And that's great. But let's talk about what an LLC actually is. An LLC is a business entity. Okay. It can have nothing or everything to do with the actual product or service or talent that you feel you provide to the world, right? It is a business entity. That's it. Now, your business entity, your LLC, can then turn around and provide services, provide products, provide talent. It can also own assets and own things. So what you would be copywriting is not the LLC. You could potentially trademark a phrase that is the LLC, but what you're really trademarking is the brand. And you can only trademark something as it pertains to a class. What's a class?
Yeah.
A class is either a service or a product. And there's this long, exhaustive list of classes that the USPTO has. The USPTO is a U.S. patent trademark organization. And it says that these things fit in this class. So apparel, 35 is a class, or 25. I can't even remember at this point. But it's a class, right? And under this class for apparel, you can have hoodies, t-shirts, women's blouses, men's clothes, like all these things. So you could trademark a brand because your brand is used to sell or market blazers. So you would trademark my brand blazer, whatever your brand is, pertaining to apparel. But your LLC could be named I Make Clothes LLC.
Okay.
But if your brand is my brand blazers, then you would trademark my brand blazers. So
you can trademark the operation.
You trademark the brand, so the label, so what you're selling, or you trademark the phrase if it pertains to something specific. Just Do It is a trademark phrase for Nike. They trademark it, I think, probably in advertising. There's probably different classes. Nike is the name of a company. It's a corporation. It's an entity. Nike is also a brand of clothing. Nike, the company, owns Jordan brand. So they also own the Jordan trademark. So Nike, the company, owns Nike trademark, Jordan trademark, Nike Check trademark. You see what I'm saying? So there's kind of levels to that. But yes, in theory, if you start an LLC, you offer a service and you do so specifically in a way that it's used in commerce. So you're actually actively out here trying to make money doing it, right? And you specifically, if you're doing it across state lines, the easiest way to do that is on the internet because people anywhere can find it. And you feel like you need to protect that brand, like nobody else can't make t-shirts under the brand I Make T-shirts. Like that's my brand name. Then you can trademark it. But so that's kind of how that works.
Okay. And it gets harder in the creator space because it's like, it's my name or it's like my username and things like that. And it's like, well, you make content you don't own a business behind its name. This business does not operate or provide any service. You, the creator, one person, right?
Well, so you can
Okay.
own a trademark personally.
Okay.
So in theory, you, Isaiah, can say, hey, I've got this brand and I want to own this trademark for this thing I'm doing. You can. Or you can apply for the trademark under your business name. So a business can own it, a person can own it. What gets muddy for content creators is the premise of what they do is putting it out into the public, right? So that's why it can get a little muddy in the water, because it's like, is it just you? Is it something you've seen and you're basically replicating it under fair use? Or is it something that's trendy that everybody's kind of doing? Like, what is it?
Yeah.
But yeah, content creators can definitely benefit from intellectual property kind of protection. It's just they have to be careful about how. And some of that is through copyright or trademark, not so much patents, but it could be. But some of it is just through like good legal contracts.
And we have a few questions on that. Okay. They probably finna be calling you after this. They're gonna be hitting your office up. So okay, I want to lead into my next question. So if a creator or influencer considers themselves self-employed, then is their content considered a business asset? So kind of like exploring it a little bit more.
It could be, but here's the deal. When you're self-employed, you still should have some kind of business entity. That's just from a liability perspective, right? Because what that allows you to do is separate personal from business, expenses, assets, and income, which is important. I am not a tax attorney, but it is important to have those things separate. And then it allows you to operate with some liability protection. But yes, if I work for myself, I'm a content creator, then depending on what I do, it could be considered a business asset.
Now that is pivotal. That's pivotal. Okay. Are y'all listening, people? I hope you just caught that drop, because that's actually really important. I think now moving, honestly, after kind of COVID 2020 increased the height in content creators or the interest in the industry. And so after last year, just what I'm noticing from the corporate side is like, we're spending thousands on influencers right now. And a lot of them are not like, they pay the taxes themselves. Like, it's just, oh, okay, well, send me the net 90, send me the net 30, right? Not send my business or write that off to my business. So I think if a lot of them would start to consider themselves self-employed and then get legalized as self-employed or LLC, whatever the protection will be for them, that'll be really helpful. Okay, cool. So another question that I have, and I think will be a good follow-up to this, is how can content creators or influencers protect their content ideas or unique activations?
Okay, so very loaded question. Again, they can there's a couple things. They could take advantage of things like trademarks, right? If it's something that they're going to be doing and exploiting. So for instance, some content creators, I know they're like, I'm a lifestyle content creator, right? And eventually they're like, oh, I'm constantly showing my home and all the things I do in my home. And, I've got all these posts and reels. And I decided I love candles. So now I'm going to come out with a line of candles. And they brand it. So that's something that they can literally trademark, right? They've put their brand on this thing. They can trademark it that way. So they can take advantage of trademarks. If they're writing, specifically content creators that, like, for lack of a better word, make their money writing jingles, poems, things that they want people to use, but they want to get them licensed so that they get paid for them, those could be copywritten. Also, like, really and truly, contracts agreements. And a contract isn't just like here's a contract because I'm giving you a service. Like, there are all kinds of contracts, but to have those in place when they decide that they're going to interface with or collaborate with other people, influencers, entities, brands. to have the right kind of like contracts in place. And then not boilerplate contracts, not download off the internet contracts. Something
Yes, that's the good one.
written, right? A lawyer in your state has actually written, or something a lawyer in your state or the jurisdiction where you're going to be doing business has actually reviewed and giving you feedback and made updates in your favor. Like, it's very important to have legal review of everything coming in. And then if it's an agreement you're sending out, it should be promulgated by an attorney. It should be drafted by an attorney. I know that there are a lot of places we can get things online. However,
yes, it's not always useful.
It's not always useful. It's not always useful.
And so I have a question because, well, no, not a question. A definition can you provide me? You said propagate. What is that?
Oh, I said promulgate. So like
Propagate. Okay.
It basically means created, put together. So a lot of times I hear realtors say it all the time. They'll be like, oh, these are TREC contracts, which is like the Texas Real Estate, I think Texas Real Estate Commission. They promulgate these contracts, which means they basically work with industry experts and attorneys to create a document that all realtors can use in Texas that is already legally vetted, right? It's not like if a realtor or a realtor finds or downloads this TREC contract that they have to go get an attorney to review it. Like, as is, it's already been vetted. So that's basically what it means.
Are you, and this could be just a no question or a yes, but do you know of any like creator propagate? Am I saying, I'm so saying it incorrectly.
Okay.
Let's go to English class real quick. Step out of marketing to English. Can you say that for me one more time? Promulgate.
Yeah.
Okay, like pomegranate. Okay. Anyways, I'm not gonna embarrass myself like this. It's fine. But yes, do you know of any like pre-made contracts? Well, now you just said don't download off the internet.
So there are websites that have them. I mean, literally, you can throw a rock and hit a website that has contracts for creators. And I'm not saying they're bad contracts. I personally know lawyers that's how they make their money. They create contracts, they create a website, and you can go download the contracts. The difference is they may be located in North Dakota. If you live in Illinois, your state law could be different than North Dakota law. So if you're going to say, hey, these are written by an attorney, they look really good, it costs me way less to get one of these. I'm not saying don't do it. I'm saying if you do that, have somebody review it in your state. Like, you got to have somebody review it that knows your local laws, because every state has different laws about how things can or cannot be done. So I would, if people want to find an online contract, they just got to Google contracts for X, contracts for influencers, contracts for whatever. But again, buyer beware.
Yeah. And then go get that review too, because those nuances won't be added in.
Absolutely. I will say my clients that are influencers, their contracts are contracts that I wrote. Like, now most of them didn't do that off the bat. They probably started with online contracts, but once they started to really earn more and the stakes got a little bit higher and they needed more protection, or they needed more teeth in their contracts to enforce some things, then they were like, you know what? Who am I to say it's too much to pay an attorney XYZ dollars an hour when I'm over here trying to make $30,000 on a post? Like, let me go ahead and get
make those proper business investments.
Yeah, let me do that. So
yeah, because I know a lot of times, like so I can speak from corporate side, right? We'll send you a content brief, and on that brief we have brand guidelines. And so it's kind of like our contracts, because once you sign it and you agree to these guidelines, you have to follow those. Like, you have to provide back what we asked of you. And so a lot of times when I was first starting my career a few years ago, like, I was just getting into influencers, like just getting into it. And like, I would realize, again, this is from the friend side, my friends would just like receive a brief, read it, see the amount, see the net date, like this net 30, net 90, 120, whatever the case. Oh, blue check, content created. But then, like, once the years pass, they're paying the taxes on those gifts. They're paying the taxes on like that money received, and they're like, "Oh, wait, well, I didn't get this back, or I didn't get that back."
Mhm.
Well, you just read your brief, and you signed your brief. You had no legal representation. They didn't read it. There were no contracts in place, just the brief. So I think that's very important for them. Ooh, so this one can be. I would actually like if you would spotlight your agency. And kind of talk about your firm a bit with this next question. But what kinds of contracts should content creators be looking for?
Okay. So my firm is J. Jackson Law Office. And we do all kinds of legal work, all kinds. But like I said, I really focus on business, estate planning, and probate. So these are the things I think every creator should have at some point. Some kind of service or talent agreement. And that's outgoing. These are the services I provide at this rate or price or cost. This is how I provide them, and this is how I need to be paid. And then it will have other paragraphs, other clauses that talk about in the event of non-payment, or that talk about what state law applies, so on and so forth, and protections. So service and or talent agreement.
Okay.
Work for hire agreement, because content creators don't do everything themselves. Somebody over here capturing that content, editing that content, they doing that hair makeup. Somebody is doing something. So a work for hire agreement that says, hey, you are my go-to photographer. You are my go-to videographer. You don't own the rights to this work. You don't own the rights to these images in this video. I do. This is a work for hire. This is the scope of work included in the work for hire. And this is what I'm paying you for it. And you're releasing all rights to it, to me, because I want to own the IP rights to it.
And I never thought about that, like getting a work for hire agreement, because again, with the brief, like we don't ask who's shooting your content. As long as you hit those guidelines, we're happy. But then I have not yet to think until now, like, what does the back end look like for the creator? Like the person who was holding your phone. I don't know if you've ever experienced this, but like whenever somebody like takes your picture and they're like, tag me in the comments, or like,
yeah,
I'm a photographer. you just
like your work for hire agreement can be so simple, but it may state you understand and agree that no credit will be given. Like if that's, as a creator, if that's my thing, is that I'm not going to be tagging you every time, because I'm like, it is what it is. And if that photographer or videographer ain't down for it, then find another one. If that's what you decide you have to do, right? But you can't just not give credit if there are no boundaries drawn by an agreement. So that's why one would have a work for hire agreement that just lines out, like it lines it out. This is what we'll do. This is what you get. This is what you do not get. So on and so forth.
Exactly. That is very smart.
A collaboration agreement, especially if you're doing like a lot of brand partnerships where they're coming
UGC girlies.
Right. Especially when they're coming to you, or maybe you're equally yoked influencers and you're trying to do something together. You want some kind of you want some paperwork behind it. At the end of the day, make sure you have some paperwork behind what you're doing, right? So like, if it's a styled shoot, or and you're like, hey, I know you're the stylist, I know you're the decorator, you're the photographer, you're this, you're that, but we're not tagging all that. We're creating something for this. Like it just says this is what we're agreeing to. This is how we all say that we're going to get credit or not get credit. This is how we're getting paid or not getting paid. So collaboration agreement. It's also good for like partnerships or sponsorships. Sometimes it can be appropriate. Other things, some influencers are bigger than just their social media page. They may also have like a website. So at that point, you definitely want some terms of use. Come on my page.
True. That perpetuity.
Rip something off my page and you think it's fine, but no, you didn't see them terms of use that you could have clicked on and read all the things you can and cannot do with my content on it. And that's not necessarily like people think about contracts as something you give to somebody else, but really agreements can be used in any way. So terms of use, it just says, hey, you visited my site, my platform. These are the things you accepted. These are things you can and cannot do.
Very true.
Some influencers need an NDA. A lot of influencers have to sign NDAs, especially while they're creating whatever content they're creating until it's published.
Very true.
So that's something to be, just aware of. So those would be the main ones, I think.
Okay. Oh, wait, let's check the comments before we do a little mini Q&A session. First of all, I want to thank you right now and say this is very informative. If you all are watching and have not received the Joom, you might want to check the floor because it's right there. She dropped a few of them. So I have really enjoyed this. Thank you all. So I think we have one right here from Jai. It was up earlier. So is it good to have several trademarks that relate to different aspects of your brand to ensure everything is protected, or does one trademark protect several things?
That's a great question. So one trademark can protect several things. When we apply for trademarks, you literally have to state right then and there, this is my mark. These are all the classes it pertains to. So like, let's say your brand is Pink Straw. We just say Pink Straw is my brand. And I make t-shirts. I, sell shoes under the Pink Straw brand. I sell phone accessories under the Pink Straw brand. And maybe I sell makeup under the Pink Straw brand, all Pink Straw. On that Pink Straw application, that one mark, if I know I'm already doing all these things and I can show it, because what we have to do when we apply is we have to actually give a specimen, multiple specimens of every item that pertains to a class we claim to have use in commerce. Or you can apply and say, I'm in the process of like getting this together, but I know the trademark process can take 2 years. So
yes,
I'm going to apply 1B to be used in commerce. And in doing that, I'm going to make shoes, hoodies, makeup, and phone accessories, right? So on that application, I will list all those classes because all of
even
those
if I
things
don't have my specimen.
Right. So whether or not, like, depending on if it's a 1A or a 1B, 1A means I'm using it in commerce right now and I can prove it. 1B means I intend to use it in commerce within the next 6 months and I'll be able to show you. All right. So all of those can be on one application. And if, when it's all said and done, they all go through and they're all approved, then that one mark can protect 4 things, 4 classes. Or I can say I have Pink Straw makes the shirts and the shoes, but my company also has a brand called Picture Frame. Picture Frame is what makes my cell phone accessories. And then my makeup is Lipstick Girly. So those are 3 different trademarks for 4 different classes of objects. So you are the captain of your own ship. The only thing about that is you got to choose wisely. And you got to make sure you have a lawyer that helps you through the process to say, hey, there's already a mark that exists that might be a conflict. And you might spend all this money creating this brand. And by the time your application gets through, they're going to say, no, sir, you don't get to trademark.
Yeah.
So to answer your question, depending on how you brand what it is you do as an influencer, you could do it all under one brand or you could do it under several. But the main thing is to make sure it's a unique brand that can be trademarked, that you can show use in commerce. Those are the 3 big things.
Man. I don't have the money today, but when you send an invoice, I'll send it, okay? This is really good. Okay, good deal. Good. Okay, so I think, honestly, let me see if we have any other questions. Let's see. We just have a few. Jennifer said, this is good advice. I definitely agree with her there. Santula has said something. Let's see what she said. So she has an instructor she gets all her media training for. One of her former students copied her entire catalog. Oh, she'll take legal action. So you can copyright courses, correct? Because it's like a part of the
Yeah,
business.
it's a work. It's an authorship. You can trademark a course and you can copyright the coursework and the catalog. So you can say, my course is called, I don't know. Okay, I'll tell you one. I took a course one time called 2 Weeks to Trademarks. So she trademarked her course name, right? But then she can go back and copyright all of the stuff, all the material. So yes, that's possible. And if it's copyrighted and properly protected, then yes, you can prosecute those who try you.
Okay, I'm gonna hire you. I need a you in my life, I think. Okay, great. So I'm going to end it with the key takeaways because we've covered a lot, right? So the simple fact, I think, bottom line is have some paperwork, people. It is that simple to mess up, and it's easier to go ahead and do the research beforehand. You have individuals like let me say it right,
McWhinney.
McWhinney. You have individuals like Miss McWhinney here who can literally provide you A to Z and help, right? So like she can get you started and finished. So from your legal perspective, what will be the key takeaways a content creator should hear today?
I think just make sure once you decide it's not a hobby, that's
Right.
the first thing. Because all of this stuff costs money, right?
Yes, it
All
is.
So, once you decide it's not a hobby, I would say the first thing is have somebody that you can trust to advise you.
Mhm.
A lawyer who really understands business, or somebody that's maybe a veteran in that area and can point you to the right advisors. And doing so, that lawyer or that advisor will be able to tell you, okay, what are you trying to do next? All right, this is probably what you need to go and get now. You need to like level up. Because it's a lot to do at once. I don't recommend anybody I'm gonna be a content creator and the next day be like, I need a trademark, I need this, I need that. But you gotta have a roadmap, right? So sometimes you pay for advice just so you can get a good roadmap. That's the first takeaway. The second is know what kind of value you're providing the public. And once you realize what you do that's valuable to the public, in other words, what gets the clicks, the likes, the shares, the whatever, focus on maybe branding one of those signature things so that that's the thing that you protect, that you invest in. I wouldn't at the beginning spend a whole lot of money and time trying to like do everything, but like eventually you kind of know what your niche is and you know where your bread is buttered. So that's what you'd focus on protecting. The third, definitely have some contracts in your back pocket, preferably drafted by an attorney. I'm not going to be one of those lawyers that say nobody uses attorney contracts from online. That's a lie. People do. Preferably drafted by an attorney. But if you cannot afford that, find one and have it reviewed. At least do that so that you're protected. And then finally, just know that like if you're going to take the steps to protect your IP, if you're going to take the steps to copyright, to go get a patent, to trademark, you also need to be prepared and willing to spend money to prosecute people who infringe on your IP rights. There is no benefit to having a trademark or a copyright if you are going to let people rip you off and do nothing about it.
Yes.
What's the point? So the young lady that said she knew somebody who had to basically sue because somebody, that's what you got to be prepared to do. That's how you protect it. That's how you get paid back. So
it's a hefty investment. Definitely a hefty investment, but it's a key protection as well. So I think that's a really good takeaway. Really good takeaway. Okay, thank you so much. One more time, can you tell us your law firm, how to get in contact with you, an email number?
Yeah, absolutely. You can find me on LinkedIn. I probably need to update my profile for sure. But my name's Alexia McWhinney. I'm at the J. Jackson Law Office based in Houston, Texas. But intellectual property is a federal practice. So I have clients all over the country and I can help clients all over the country. And you can reach me, A. McWhinney. You see my name on the screen. So it's A. McWhinney at our number, 855-GET-JJLaw.com.
All right, people, you heard it here first. Thank you again. Like literally, this has been very informative, extremely so. Like I'm not just trying to hype you up and make you blush. This is literally being like actionable steps. I feel like if anybody who didn't know can watch this, then they'll know. I know for myself, I work in the space, right? I'm in the space every single day, but I'm not on the creator side. I'm on the brand side. So I know like our legal protections are hefty, right? Even when I was in agency, I had my little contracts, but I never had like working agreements. I never had anything that was really substantial past that brief, right? So I think this was really good. So again, thank you so much. Everybody, please contact her if you are looking for legal advice in the creator space or just simple legal advice, because I definitely think they got somebody for you.
We got somebody for you.
Oh, yeah, they got somebody for you. So thank you again. And I'll end this now for us.
Bye, guys. Thank you.
Later, y'all.